Lalita Kumari vs. Govt of Uttar Pradesh, 2013. A case on the mandatory registration of FIR under Section 154 CrPC. The writ petition under Article 32 of the Constitution was filed on behalf of Lalita Kumari, who, being a minor, had approached the Supreme Court through her father, seeking a writ of Habeas Corpus for her protection after she was kidnapped. The petitioner complained that despite submitting a written report to the police on 11 May 2008, no action was taken initially. An FIR was registered only after approaching the superintendent of police, but even then, the police failed to take effective steps to arrest the accused or recover the minor child. In the previous case of Lalita Kumari vs. Govt of Uttar Pradesh of 2008, the Supreme Court had warned that failure to promptly register the FIR and provide copies could invite magistrate directions and contempt action against police officers.
In the same case, the petitioner's counsel had argued that the police must mandatorily register an FIR under Section 154 upon receiving information of a cognizable offence.
The state's counsel argued in favor of police discretion in conducting a preliminary inquiry and claimed that mandatory FIR violates Article 21 of the Indian Constitution.
Divergent judicial interpretations in earlier precedents resulted in that case being referred to a constitutional bench. The issues before the constitutional bench were whether registration of FIR under Section 154 of CrPC is mandatory, whether police can conduct a preliminary inquiry before registering FIR, and what happens when information discloses a cognizable offence.
The Supreme Court held that Section 154 of CrPC uses mandatory language. The FIR is the first step towards access to justice. It prevents manipulation and suppression of crime and ensures transparency and judicial oversight. Protects victims, especially the poor and the vulnerable. Registration of FIR does not mean automatic arrest. Arrest is governed by Section 41 of the CrPC. Safeguards regarding arrest are laid down in the case of Joginder Kumar vs. State of Uttar Pradesh. Moreover, the accused can always seek anticipatory bail under Section 438 of the CrPC. The Supreme Court held that adequate safeguards exist against arbitrary arrest. Moreover, victim rights are equally protected under the Constitution. The Supreme Court further held that preliminary inquiry can be allowed only if a cognizable offence is not clear and to ascertain whether a cognizable offence is disclosed, and not to verify truth or credibility of the allegations. The inquiry must be time-bound and completed within 7 days. The Supreme Court provided an illustrative list of categories for conducting a preliminary inquiry, including cases of commercial offences, medical negligence cases, corruption cases, matrimonial and family disputes, abnormal delay in filing complaint. Finally, the Supreme Court held that FIR is mandatory if a cognizable offence is disclosed. If not, then a limited inquiry should be conducted. If a cognizable offence is confirmed, then FIR should be registered, or if not confirmed, then the complaint should be closed, with reasons to be given in writing within 1 week. Any inquiry must be time-bound and completed within 7 days.
This case is a landmark ruling on FIR registration. It strengthens rule of law, enhances police accountability, and protects victims' access to justice. The ruling in this case continues to guide criminal procedure in India. Thanks for watching.